Good day to all. Welcome back. My topic for today's lecture is evolution of law of carriages, definition of contract of carriage, definition of carrier, and different kinds of carrier. So, let me go into the topic without much delay. So, first is definition of contract of carriage. These types of carriages or these type of contracts are also known as contracts of transportation because contract of carriage is a subset of contracts under the bailment contracts, and bailment contract is a special type of contract under contractual law. So basically, if you draw a Venn diagram, we can see that there is a whole contract law. It is bailment is a species in it, and contract of carriages is a species under the bailment law. So that is the evolution, or basically that is how it evolved into more concentrated form. And contract of carriage may be defined as a contract whereby a professional carrier engages to carry goods and or persons in accordance with a determined mode of transport and within a reasonable time, with the understanding that the carriage is a principal object of the contract. Now, basically, as like any other contract, it defines the rights, liabilities, duties of the parties to the contract. Now, let's see the parties to the contract of carriage. Basically, there are three parties: the consignor, who is the owner of the goods; next one is the carrier, the person who is undertaking this professional service; and nextly, the recipient of goods, known as a consignee. Basically, the contract exists between the consignor and the carrier, but consignee is also having a remedy under the contractual law of carriages because the goods has to reach the consignee. So basically, any defect to the goods, any damage or any injury, in most cases, would be suffered by the consignee. So even though consignee is a third party, that person will be also having a remedy under the contractual law because he has suffered that harm or injury due to the deficiency in service from the side of the carrier. So basically, carrier will be responsible for that if that has happened during the course of his employment. Next one is classification of contract of carriage. So basically, there are two broad categories. First one is the carriage of goods. Next one is the carriage of persons. Our topic of study is mostly confined to the carriage of goods aspect, but there are statutes or legislations in India that deals with both. For example, Motor Vehicles Act of 1988 and Railways Act of 1989. They both contain similar provisions regarding the carriage of persons aspect. But as I said, we have to look more clearly into the carriage of goods aspect. So basically, based on the mode of transportation, it can be classified. That is carriage by land, carriage by air, carriage by sea, and multimodal transportation. Because in most cases nowadays, due to the increased globalization and since cargo is exported and imported at a higher rate among the countries, so there could be multimodal transportation because at a stretch or in a particular transaction, both land, air, and sea could be used. So regarding like if multimodal transportation laws are not there, then we'll have to apply each portion of law to each set of transaction, which is quite cumbersome and quite not warranted also. So to avoid this, we have the multimodal transportation laws, and the land laws can be divided into road and railways. Now we have for the road we have the Carriage of Goods by Road Act of 2007. For the Railways Act of 1989. Air we have the Carriage by Air Act of 1972, which is a national legislation giving effect to the Montreal Convention to which India is a party. Carriage by Sea, Indian Bill of Lading Act of 1856. Carriage of Goods by Sea Act of 1925, again giving effect to the Brussels Convention. Next one is the Merchant Shipping Act of 1958. And for multimodal transportation, we have Multimodal Transportation of Goods Act of 1993. So now we look on to the evolution of carriage law aspect. It basically evolved from the Roman law because it did not achieve a distinct contractual form status, but then they were treated as deposit or hire of services of goods. Basically, they were treated as depositories. These carriers were treated as depositories, and they would be liable without fault for destruction or damage to the goods or passengers, which means they were absolutely liable for any damage caused to the goods while the goods were in possession, within their possession. And only defense available is the irresistible force or the act of God or force majeure. That is the only defense available, and it is very difficult to prove them also during that time. And in most cases, they were absolutely held liable. Now, in English common law, as I've already said, it developed from the bailment laws. So, carrier was considered as a bailee, and he was liable to the bailer. Bailer means, in the earlier slide we saw it was a consigner. Bailer is the exact equivalent to the consigner, and if he who was liable to the bailer if he failed to deliver the goods intact. So it is not the delivery part that requires importance. The mode of delivering, the mode of carrying, the way you deliver, all these things acquire importance when it comes to English common law. And we know that under English common law there is nothing written. Everything is it has been evolved through English decisions and judicial pronouncement. So through various case laws, it has been held that the carrier's obligation is not only to simply carry goods, but to carry them safely and to deliver them properly to the consignee. And they'll be liable for the loss of good. Here also absolute liability is there for any damage to the goods during that has happened to the goods while they were in its possession. But then there are certain accepted causes like act of God, foreign enemies, the goods not properly packed, any inherent vice. All these things are accepted causes, but still absolute liability is a major rule. Next one is the duty of carrier to deliver the goods safely was considered to exist without regard to obligations arising under any special contract between the parties. So basically, the delivery of goods between the consignor and the carrier is considered to be an implied contract, and no special contract can reduce the liability between them. A liability arises from common law. In civil law countries, we have the French Civil Code of 1804. They treated carriage contracts as contract for hire of services, and they were treated as depositories. But the French Commercial Code elevated their status, making the contract of carriage a distinct contractual form. So now today in civil law world, the contract of carriage may be regarded as a variation of the contract of hire of services. They properly distinguish. The 1807 code properly distinguished depositories from professional carriers, and it is a contract whereby one of the parties engages to do something for the other party in consideration of a price agreed upon between them. And the contract of carriages under the French laws, under the civil law countries, require three major elements, and they are the carriage, control of operation, and a professional carrier. If any of these elements are missing, then the contract is one of the hire of services and not a special contract of carriage. Next, we have the sea carriage. Nothing much to deal there. Industrial revolution was a major important ingredient that led to the expansion of maritime commerce on a world scale, and this led to the International Convention for the Unification of certain rules of law relating to the bills of lading, and we have the Bills of Lading Act in 1925 in India. So that the impetus came from this international agreement. Now we have the air carriage. The Warsaw Convention, as amended by the Hague Protocol, was a major step towards international unification, and it has to be noted that this convention applies to the international carriage of both goods, persons, luggage, goods for reward, even the gratuitous carriage, and even to private owned aircrafts, public owned aircraft, or even the purely state owned aircrafts also. So nothing is spared from its purview. Now, certain international developments, Bern Conventions, Brussels Conventions, and the Warsaw Conventions, and they all improved the contract of carriages in and around the world. And during the Cold War, the countries of Eastern Europe established a uniform regime for the movement of goods by railway that was comparable to the Bern Conventions. And the Geneva Convention of 1956, it was for carriage of goods by road, but then during that time itself it covered mixed carrier transportation or the multimodal transportation. Next one is, who are carriers? Carrier is a person or entity engaged in the business of transporting goods or persons or both. They actually give out a professional service and they charge a consideration for their employment. Now let's see the type of carriers. The most common type or the most prominent one is a common carrier. Next we have the private carrier as against common carrier. Next the gratuitous carrier, public carrier and the government carrier. So let's see what are the duties and liabilities of these carriers. First one is common carrier. So basically common carrier, we have the Carriers Act of 1856. They denote a person other than the government engaged in the business of transporting property under multimodal transport document or of transporting for hire property from place to place by land or inland navigation for all persons without any discrimination. So from the definition, this is the definition given under the Carriers Act. So from the definition, it is quite clear that government is totally excluded. Government carriers are totally excluded from the purview of common carriers. Common carriers, the purview of sea carriage and the air carriage is not given here. Only the land and inland navigation is told in the particular definition. These persons have to do the carriage process, carriage services without any discrimination, which means whoever approaches them, they are supposed to give their services. They cannot discriminate or they cannot accept or refuse according to their whims and fancies because they are conducting a professional service. So this is what you get from the common carrier definition given under the Carriers Act, and this definition has evolved from the English law. And most of the Indian law has emerged from the English law and particularly the carriage law also. A common carrier is a person who publicly professes to undertake for reward to transport the goods of all such persons who wishes to employ him. And the definition of Carriers Act in 1865 is based on this definition of Carriers Act under 1830 England law. So the Lord Holt has defined common carriers as public trust because they are conducting a public duty, and common carriers are the public trust for transportation, so they acquire a more wider prominence unlike the other jurisdictions because it is felt that they owe a duty to the public in general. That is why they are held absolutely liable when the goods are in their possession. And if any special contract is made between the consignor and the carrier limiting the liability, then that contract will not have any effect if it contravenes the provisions of Carriers Act, because then liability given under the Carriers Act is a standard liability. You can only increase your liability through special contracts, not decrease it. That is under the garb of a special contract. You cannot commit any kind of negligence. You cannot take it as a license to commit further negligences. So that is the importance of special contracts under the Common Carriers Act of 1865. And duties, there are a lot of duties. Now, I'm not going to deal the whole of the duties because it's somebody else's topic, I guess. So basically, they have the duty to accept and carry without any discrimination, and they have the duty to follow the instructions of concern if they are given particularly, duty to deliver within reasonable time, duty not to deviate from the usual course of passage unless there is very genuine reasons for that, duty to deliver against documented and warranty of roadworthiness, which means the mode by which they are transporting, be it the truck or the rails or anything like that, they have to make sure that the roadworthiness of the particular vehicle is good enough that they can transport it without causing any injury to the goods, and they have to ensure that the goods they are transporting will be well carried and delivered at the reasonable time at the correct place within the as stipulated by the consignor. So all these things are important. In reverse steam navigation, there are a lot of cases dealing with the common carrier concept. In reverse steam navigation company versus Shyam Sundar Tea Company Limited, basically the question was who was a common carrier. That is, they profess themselves to be common carriers, and then they indulged in a free service, a gratuitous service, and the whole of the transaction, at least one fourth of the transaction, they did it free of cost and not in the usual course of passage. So during that time, negligence happened and it caused a damage to the goods. So it was told that it was understood that they contended that they are not the carriers, but the court held that the Supreme Court of India held that they are the carriers because they profess themselves to be carriers, and the public saw them as carriers. So in this context, they are held to be liable and they are common carriers, even though they gave it free of cost, and even though they did the professional service not in the usual route. Now, the private carrier, as against common carrier, private carrier is a person who, in the course of business or occasionally, undertakes the carriage of passengers or goods. And he does not hold himself out as an exercising the public employment of a common carrier. A carrier who, while inviting all, reserves to himself the right of accepting or rejecting their offers of goods for carriage, whether his vehicles are full or empty, being guided in his decision by the attractiveness or otherwise of a particular offer and not by his ability or inability to carry, having regard to his other engagements, is a private carrier. This definition is given under the Halsbury Laws of England, and this is a very classical definition of private carrier. That is, private carrier enjoys a lot of freedom in deciding whether to accept the goods, whether to reject the goods, and he is not answerable to anyone for his decisions. So basically, any person who is not a common carrier is a private carrier. And the difference between the common carrier and private carrier: common carrier, he carries the goods as a regular business to earn money. Private, he carries the goods occasionally. Common, he carries the goods without any discrimination. If he discriminates, then he'll be liable. Private carrier, he carries the goods of particular persons. He can surely discriminate. Nobody is going to answer them. He is not answerable to anyone. Common carrier, he declares a schedule of service as per the Carriers Act. Private carrier, he has no such thing as schedule of service or anything. Common carrier, he cannot refuse to accept the goods without any reasonable cause. Private carrier, he has the option to accept or refuse to carry goods. Common carrier, he is governed by Carriers Act. Private carrier, it is related to the bailment, so he is dealt under the bailment chapter, section 151, 152 of the Contract Act. Now, who is a public carrier? Public carrier is much like a common carrier, but then it is used in civil law jurisdictions. So, public carrier is a professional carrier of goods or passengers, and public carriers, like common carriers in common law countries, are subjected to strict economic regulations and are under the supervision and control of administrative agencies. So, there is a lot more control over them. When a public carrier is also a professional merchant, normally an individual or a private corporation, he assumes all the duties, obligations, and liabilities attaching to merchants under appreciable commercial courts of special legislation. But like a common carrier, what is the similarity between common carrier and public carrier? That is, they must accept goods lawfully delivered to him because he is held to be a permanent offer made to the public, or because he is under obligation to carry by virtue of a public legislation or administrative regulation. So their duty to the public is so strong that it has got legislative backing. But the difference is that they are not liable for loss or damage to goods without fault, public carriers. This difference is more apparent than real because carriers in civil law systems are presumed to be liable unless they prove that the loss or damage occurred without their fault. So, for any loss or damage that occurred without their fault, public carriers are not liable. But common carriers will be liable. They have absolute liability unless it comes under the accepted cost provisions. So, this is the basic difference between public carrier and common carrier. Next, we have the gratuitous carrier. From the word itself, we know that it is given free of service. So, any contract of carriage given free of charge, he is a gratuitous carrier. So, it can be done for both goods and persons. And next set of carrier is government carriers. From the terminology itself, it is understood that those carriers are recruited and employed by the government agencies, departments, or undertakings to conduct carriage business for the state. Of course, they are doing it for a profit, which goes to the government treasury. And always there will be a statutory backing because a particular legislation will control the rights, duties, liabilities, etc. of the people, of the carriers owned and controlled by the government carriers. For example, we have the Indian Telegraph Act. We always send carriers and we always send couriers through telegram, through using the postal services. So it is governed by some other act, and those acts will be those acts will be governed. Those act governs the carriers, government carriers. So it is not that they are not at all regulated; they are regulated in some other way by the state. So that's all regarding my topic. So I hope the topic is clear. Thank you.